If they're pulling you over and they start talking about alcohol, you're getting arrested. You're not going home. You're going to take the sobriety test and you're going to fail. It only takes two clues out of 20 total clues in order to justify to a judge that you may have been intoxicated. That's all probable cause is, right? A 12% chance. That's it. So, best to just don't go around explaining yourself because that's just going to cause problems.
All right, that's great. I think a lot of people will benefit from hearing that. No doubt about it. Because when they don't listen to us or our advice, it makes the case more difficult. And especially in a case like this on the front end, most people don't know how they should respond until they're in that situation. So you've given some nuggets that I think a lot of people will be able to use in Texas and Louisiana, and quite frankly, I think in probably every state in this country, that advice is sound. So that's great. So I want to know, like, what is your process for dismantling or tearing apart the prosecution's evidence and creating a strong defense for your clients?
The main thing that I do is I evaluate the evidence. Look, I wait till all the evidence is in, and then that's when I do my evaluation. I'm trying to look at everything. I try to make sure that I know the law, and I question every time that they've made a conclusion. I've now seen enough cases where I am seeing the same language come up over and over again. So I kind of know where that should lead to. And a lot of times it doesn't lead to what people say. And then the main thing is I prepare, right? But I'll give you an example where a lot of times you'll see the language of the person supposedly was driving intoxicated.